Welcome, everyone. Good morning, good afternoon, and good evening. Thank you all for joining us today. It is so great to see that there is so much interest from around the world in today's conversation. In fact, about 270 people from more than 52 countries have registered for this event. And welcome to everyone who has tuned in. My name is Savita Pandey, and I'm the Deputy Executive Director of the Global Center for the Responsibility to Protect. Tomorrow, the world will commemorate the World Day for International Justice. And this year marks the 15th anniversary for the Responsibility to Protect. So in honor of the World Day for International Justice and the 15th anniversary of the Responsibility to Protect, the Global Center decided to bring together a panel of international experts and practitioners to reflect upon the role of international justice system in preventing atrocities. As you know, in addition to the progress made by the International Criminal Court and the international tribunals, in the past decade, the international community has developed a number of innovative mechanisms to ensure accountability for war crimes, crimes against humanity, and genocide. This includes the establishment of hybrid courts, the authorization of a variety of independent investigative mechanisms, the application of universal jurisdiction, as well as the historic case filed by the Gambia at the International Court of Justice against Myanmar for failing to uphold its obligation under the Genocide Convention. During today's conversation, our four panelists will draw upon their unique expertise and discuss how international justice mechanisms have been useful in preventing and punishing atrocity crimes, as well as what can we learn from the proliferation of accountability mechanisms and the ongoing struggle to advance international justice. Just a couple of housekeeping items before we begin this very, very interesting conversation. This event is going to be recorded and will be uploaded on our website as well as our YouTube channel. We encourage everyone in the audience to submit questions through the Q&A function at the bottom of your Zoom screen. When you submit questions, please identify yourself, your affiliation, or where in the world you are joining us from. Throughout the event, please interact with us on Twitter by tagging us at GCR2P and by using the hashtag R2P15. Now let me quickly introduce our panelists. We have, the Ambassador Stephen Rapp needs no introduction, but here is just a very quick one for him. So Ambassador Rapp is currently, he's the senior fellow both at the Center for Prevention of Genocide at the US Holocaust Memorial Museum and at the Peace and Security Program at Oxford University's Blavatnik School. Among many other things, he has served as Ambassador at Large, heading the Office of Global Criminal Justice in the US State Department. He was the prosecutor of the Special Court for Sierra Leone, responsible for the prosecution of former Liberian President Charles Taylor and others, and served as a senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda. Professor Charles Jallow is the professor of law at Florida International University and is a member of the United Nations International Law Commission. He was an associate legal officer in the International Criminal Tribunal for Rwanda, working on high-profile cases. He was a legal advisor in the Special Court for Sierra Leone, where he was the duty counsel and the head of the Public Defender's Office in the Hague trial of former Liberian President Charles Taylor, and he was a visiting professional at the International Criminal Court. Priya Pillai is the international lawyer and head of the Asia Justice Coalition Secretariat. She has worked at the International Federation of Red Cross and Red Crescent Societies. She has worked at the United Nations International Criminal Tribunal for the former Yugoslavia and with various civil society organizations on the implementation of international law. Bjorn Eiermann, an old friend of the Global Center, is a legal officer and special assistant to the head of the International Impartial and Independent Mechanism for Syria. He has worked as legal advisor for the permanent mission of Liechtenstein to the United Nations in New York, and he was also the former R2P focal point for Liechtenstein. So without further delay, let me just jump into the conversation. And the first question is for Ambassador Rapp. Ambassador Rapp, as the ambassador at large for the global criminal justice, you coordinated US government support to international criminal tribunals and to hybrid and national courts responsible for prosecuting persons charged with atrocity crimes. During this time, individual states were empowered to create a variety of mechanisms. Based on your experience, do you think this has strengthened the international justice system?
Well, there's been some strengthening, frankly, even in this time of real setback, when the wind's been blowing against global human rights and international criminal justice. I often use the sort of wave metaphor, talk about we're now having a sort of a third wave of international justice, where the first wave was the victorious powers after World War II in Nuremberg and Tokyo. The second wave, largely through the great powers and the Security Council, with the ad hoc tribunals, with negotiation for hybrids, even for Security Council referrals to the ICC. But this third wave is really coming sort of from the bottom up, and represents all of the work of civil society organizations that are taking the law and the norms that have been established and enforced at these other tribunals and bringing them into courts in a variety of forums. And you know, it's not something great powers can prevent or restrain. And we see it particularly in the area of Syria, where we had, of course, the Security Council blocked by 2 vetoes, a 13-2 vote from going into Syria. But instead, we're now seeing very active universal jurisdiction prosecution in Germany, investigations in France, Sweden, Austria, elsewhere. And this has benefited from the documentation that's frankly been supported by states, by their donations, sometimes by foundations that have really developed the open source, sometimes the material seized on the battlefields, and frankly, in the Syrian context, have built a better trove of evidence than we've had since Nuremberg. And then have found ways to use universal jurisdiction. Controversial, certainly in the past in Spain and Belgium and curtailed, but particularly where the countries in Europe have been so impacted by the refugees, Germany taking 800,000 and have so many witnesses, and really wouldn't have those refugees if it weren't for these mass crimes that made life so impossible for people. There's a recognition that really is a legitimate way to go. That's benefited enormously, seeing Jorn here and recalling Liechtenstein's leadership on the creation of the independent mechanism for Syria by the General Assembly by a vote of 105 to 15 at the end of 2016. And this is an international body now, thanks to the support of states, not large ones, but others that worked very hard, German leadership, for instance, to get funding through the General Assembly, not having to go hat in hand for funding. This is given real strength to the process and helped ensure the neutrality of the evidence, that it's not biased in favor of those who paid for its collection, and has allowed a better path into courts that appropriately can exercise jurisdiction. Of course, we have the ICC there, and we have the challenge certainly of the US recent executive order, which is an American, I will say is outrageous, and I've joined many efforts to denounce it, frankly, really on 3 grounds. I mean, one, the United States has always been a leader on these cases. Even in the last administration, we took a leadership role in supporting the ICC in each of its cases, and that leadership is very important. Secondly, you know, it strengthens the scofflaws. Others that will be opposing justice, who don't want, who you know are under the ICC or members, and they're not wanting to comply. They'll say, "Look at the U.S. They're defying it." So it just strengthens all the people that all the wrong actors, puts us on the wrong side. And then, and frankly, from a U.S. standpoint, as General Wesley Clark recently wrote in Foreign Policy, we have a capacity to deal with this without defying the court. We can use our own justice system. We see the roadmap and what the Senate Intelligence Committee has done with its 6,000-page report, and properly investigated ourselves. Of course, that's all been undermined by the Trump administration and what it's done to actually pardon people who the military justice system are going after for attacks on civilians. The ICC at the moment obviously is going through this internal review. I personally and many supporters in the United States wants that to succeed. The court's been challenged even in those areas where it's got the whole body of the case, where it's got territorial and active personality jurisdiction, such as in Kenya or in the Bemba case or in the case from Cote d'Ivoire. And obviously it needs to succeed in those situations. Of course, it's also gone broader than that into cases where it's sort of grabbing cases because one power or another has put its arm into a situation. And that's entirely legitimate. I mean, any country can assign its territorial jurisdiction to any system that it wishes, as long as it's consistent with international human rights law. So clearly, Afghanistan has jurisdiction to prosecute people that commit crimes on its territory, and it can give it to the ICC. But those are, obviously, they also implicate Russia in the case of Georgia and in Ukraine, a preliminary examination. Those will be more difficult, frankly, to get cooperation and succeed at. And more recently, though I'm very excited about them, we have these cases where the ICC may have be able to grab a finger of the case and maybe bring it all in. You continue the body metaphor, but in the case of forced deportation of the Rohingya into Bangladesh, the only part of the crime is that crossing of the plane of the border, which is an essential element, and perhaps that allows all of the violence involved in the forced deportation to be dealt with. I was intrigued by the recent filing by attorneys on behalf of Uyghurs that are trying to do, to some extent, the same kind of thing, though from a different direction, looking at the threats against Chinese Uyghur, the threats by China and by Chinese actors against third states that are in the ICC, intimidation of refugees in those states, creating a situation where those people are essentially forced back in to China from Cambodia or from Tajikistan. Actually, you've got more of that crime, more than maybe a few fingers of the crime happening in the state party. These are exciting, but at the same time, we'd like to see other avenues because it's going to be very hard for them to succeed. And that's why the case in the ICJ, I think, is so interesting. The leadership of Abubakar Tamadou that brought that case under the ergo omnis concept of the Genocide Convention on behalf of the Gambia against Myanmar, and the wonderful argument where the government of Myanmar and its state consular Aung San Suu Kyi came to the ICJ. It's not going to be a criminal case, how much it can actually enforce. There's the specific intent issue. But it's an example, I think, particularly a person like Tamadou, who learned all of this at an international tribunal with us in Arusha. We can see how the seeds of this movement have been planted all over. And when these things come back to us from the grassroots, from bottom up, in a way, I think we can see positive aspects of this whole movement. It's not going away, even with the challenges, the confrontations, the scofflaw attitude of the U.S. government with this executive order. It's still there and will be. And I think all of us that believe in the project need to do what we can to strengthen it and to improve cooperation in the hope that we can, as the title of this thing suggests, create the perception that if you do the crime, you'll have to do the time. And by having that perception, deter these mass atrocities and in effect, in another way, implement the responsibility to protect globally. Thank you.
No, thank you very much for that. And that's much more of a positive response than I was expecting. But I mean, it's really important to understand that it's, with the retreat of great powers, what we are seeing is a lot of efforts which are coming from smaller states like the Gambia or the Liechtensteins, or sort of the work of the civil society organization. I mean, Priya's organization has done fantastic work around some of these different cases. And I want to just open up this question to the rest of the panelists too, that, Ambassador Rapp talked about this, but do you think that will the current international political climate and this retreat from multilateral cooperation, we're seeing a lot of sort of grassroots and bottoms-up approaches, But this retreat, will it damage international justice? I mean, particularly the recent attacks on International Criminal Court. I mean, does anybody, want to jump into that conversation and add to what Ambassador Rapp said? Charles?
Thank you, Savita. Can you hear me?
Yes, very, very clearly.
Okay, fantastic. Yes, no, I think, first of all, let me take a moment to commend the Global Center for the Responsibility to Protect in honor of the World Day for International Justice. I cannot imagine a more fitting way to celebrate the 15 years of the Global Center than to have a discussion, a timely discussion about the current state of international criminal justice and its possible deterrent effect when it comes to atrocity crimes. Clearly, the need for the center was obvious in 2008 to those who founded it, but perhaps that need, given the conversation we are having today, is even more so because of the need to clarify a responsibility to protect, to provide a mechanism for implementation, and very importantly, to institutionalize this within the global legal order. And to your question about where we are and how that might be going forward, I think we are seeing a retreat to some extent, but also, as Stephen pointed out, we see a couple of trends. Stephen calls it the third wave, where essentially, as he puts it, coming from the bottom up, we see some movements essentially trying to hang on to the gains that have been made in the last little while. And I think the first proposition that I would want to stress is that tomorrow would be the 22-year birthday of the International Criminal Court. The International Criminal Court is a fundamental idea. It was a big achievement of the international community that took us almost about half a century to accomplish. Now, one can argue that the ICC has faced some challenges, and that would be true, but often it is not mentioned why the ICC is facing challenges. Obviously, there is an internal dimension to the challenges that the court faces, but there's also an external dimension. And when I say external, I'm talking in particular about the role of the ICC states parties. You have a number of very difficult investigations that have been carried out by the Office of the Prosecutor, and a number of indictments that have been laid before essentially the court, and the court has approved those indictments. Yet the cooperation, which is promised to the court under Article 86 of the Rome Statute, is not forthcoming. So when we criticize the ICC's accomplishments in respect of completion of cases, I think it's very important that we also remember that the ICC is not meant to function on its own without an army, without a police force, without the support of the states that founded it. So just to underscore the point that because we are talking about international justice, in my view, the ICC ought to be a centerpiece of that system and the pushback that is necessary for states to take on the role of making real the commitments that they undertook at Rome. A second point that I'll make, and I'll leave it at that because I know we'll develop some of these in the context of this conversation, is about these other alternative mechanisms that are emerging. Clearly, there are the examples that we've just discussed concerning, for example, Syria, or if you think about Iraq, with UNITAD and so on, and these are forced by circumstance. But we've also had the examples that have developed out of the experience with the ad hoc international tribunals when it comes to, for example, hybrid courts. And I think hybrid courts are potentially a good fit for circumstances where the ICC would not have jurisdiction, in circumstances where there might be need to help build the domestic capacity to prosecute the crimes. And clearly, when you talk about hybrid courts, there are different kinds. But I'm thinking of ones that have been successful as models. For example, the Special Court for Sierra Leone, which did a great job with very limited resources that it had in dealing obviously with only one situation. You see that there was a question at one point as to whether hybrid courts would be necessary in a day of the ICC, but the state practice is suggesting that they would be necessary. So all to say that even though we have a challenge at the moment in terms of a pushback at the big institutions, what we see happening in other areas is very encouraging to me.
Thank you very much for that. And Jorn or Priya, would you like to jump into that conversation?
I think just to add to the fact that, you know, while there is a retreat perhaps of multilateralism in terms of state engagement, I do think that, you know, it's a bit of going to the mattresses in terms of CSOs saying, you know, we're doubling down and we are actually going to continue making gains, and we're actually going to ensure that, you know, that this wholesale retreat doesn't happen. So I think just in terms of the will of other actors, not just states in this entire context, is very much to ensure that there is accountability and that there is, you know, certain gains that are made are retained. So I think let's look at it in terms of not just states being the prime actors, but the international institutions, but also the PSOs and, you know, civil society, which is pretty strong around the world as well, which also has problems in terms of, you know, an assault on the work that organizations are doing. But I think nonetheless, I think there is a fair amount of sort of pushing back and saying that, you know, we're not going to let these gains go by. So just to add to that.
I mean, so basically the verdict is that the glass is half full rather than being half empty. So that's fantastic. I just want to now go back to Charles. And so given your experience with I mean, you mentioned Sierra Leone, with special courts of Sierra Leone, the International Criminal Tribunal for Rwanda, and the International Criminal Court, what impact do you think these international mechanisms have had on domestic legal institutions and their capacity to investigate and prosecute atrocity crimes?
Well, thank you again, Savita. I must say that the issue of impact that these institutional mechanisms have had on domestic legal institutions and their capacity to investigate and prosecute atrocity crimes is a complicated one. At least from the perspective of an academic, to establish some kind of causal link will require a more kind of empirical analysis, the type that we see from social scientists and increasingly from international legal scholars. So to some extent, one might say we are in the early phases of answering the question in a significantly methodological way. But when it comes to the work of the ad hoc tribunals and the ICC, and obviously institutions like the SCSL, one could at least make a number of observations based on the experience, which obviously can be somewhat subjective from person to person, but reflect, I guess, a general a set of points that can be taken away. And in my case, from having worked in the tribunals, but also spent about, at this point, about a decade and a half studying these institutions. And my answer to your question would be that overall, on balance, when we look at the different tribunals and when we look at the different situations, we can see that they've had some kind of impact. Obviously, this would be qualified by looking at the situation specifically. We will find in some cases that the tribunals that were created had a limited impact on the domestic system in terms of increasing their capacity or willingness to investigate and prosecute atrocity crimes. In other cases, we can see a significant impact. And I could just give you two examples of one of each of these with reference to the Special Court for Sierra Leone, where if we think of domestic legal institutions as just limited to domestic criminal courts, you can see that the overall position of the government was the accountability that could be had essentially was to be looked at from the point of view of the Special Court for Sierra Leone, even though there was, because of the way the conflict ended, a parallel Truth and Reconciliation Commission that obviously investigated in a significant way the atrocities and documented the atrocities that happened in Sierra Leone in a more complete way than we would have from just looking at judgments from the Special Court. It did not mean that Sierra Leone prosecuted cases in its own domestic courts. They did carry out some investigations, but there are some limitations there when it comes to the issues of resources, the Leone amnesty under Article 10 that basically from the point of view of the government, made it very difficult to prosecute. If we compare that to the Rwandan context, I mean, one could argue that there was a significant impact on Rwanda. Obviously, Rwanda had an impossible task with hundreds of thousands of perpetrators in jail, and they had to be very creative, both in terms of using the regular domestic criminal courts, where they even categorized cases based on levels of severity into 3 different camps, so to speak, 3 different baskets, and prosecuted quite a few cases, but also had to be creative in developing community-based justice in the form of gacaca, which we all know about. There was another effect that's a little bit more direct in the sense of the Rule 11-based cases, where you had transfers from the ICTR to the Rwandese system, but also changes in Rwandese law and practice when it comes to dealing with, for example, witness protection, that were essentially motivated by the fact that the tribunal kept denying the request for transfers, essentially bringing up the standard in the Rwandese system. And let me just end with one example that's slightly different in relation to the ICC. Clearly, the ICC is predicated on the idea that the domestic legal institutions themselves will do the job, right? That's the whole idea of complementarity. So it's obvious that if the ICC succeeds, it would be the case that national systems are stepping up to do it, to do the work, to do the heavy lifting in terms of investigating and prosecuting the crimes. The challenge for the ICC, of course, is that too often we've seen situations where countries want to subcontract their obligations, so to speak, to the ICC. And then when it's no longer suitable for them politically, they want to walk away. And you could give a lot of examples. Think about Uganda. If you think about the challenges we face with respect to, Sudan, obviously that one was not the state itself referring itself, was Security Council referral. But in essence, to take as a takeaway, I guess the point would be that we've seen some significant impact in some situations, and perhaps even further afield when you think about universal jurisdiction cases along the lines of what Stephen was talking about earlier. But yes, these mechanisms are having an impact at least at an anecdotal level, even though empirically we're still trying to, depending on the situation, establish that in a thorough way.
Thank you very much for that very comprehensive response. And now we'll move on to Priya. Priya, last November, the Republic of the Gambia filed a suit against Myanmar in the International Court of Justice for violating the Genocide Convention. This case is a historic moment for international justice, as it is the first time since the ICJ's establishment that the plaintiff was a state not directly affected by the crimes. This case is a reminder that even the smallest countries in the world can play an influential role in the world of international justice. What precedence has been set with this landmark case?
Thank you for your question, Savita. And also, thank you very much for having me on this panel. I think what I'll do is go back a few steps. And as you say, this is a really significant case and a very significant legal development. So just to provide a little bit of context and background of the case, and then highlight a few points that I think are really relevant to our discussion this morning. In terms of the case, as most of your audience would know, on the 11th of November last year, 2019, the Gambia filed its official application at the International Court of Justice, instituting proceedings against Myanmar, the Republic, but also asking for what are called provisional measures. So, sort of a preliminary decision for protection, essentially. The court held hearings in December, and on 23rd of January this year, issued its provisional measures order. And, as you would know, the order was a unanimous decision, including the ad hoc judges, and it was unanimously in favor of the Gambia. So I think just in terms of setting up the context, a lot of people have asked, how come it was the Gambia? Why wasn't it, for instance, Bangladesh or Malaysia that have had an influx of the Rohingya and have been, hosting these communities as well for a few years? So I think for that, we need to look at what the court has said in this provisional measures decision in January. What I would say, of course, I'd preface these comments with the caveat that, as the court has said itself, this is not a definitive decision. It's a decision in terms of issuing provisional measures, but some of the issues that have come up in this decision aren't being decided completely at this stage, and they will still come up during the course of the litigation. But having said that, I think the question, of course, that has come up is, what standing does the Gambia have, and why is this case being instituted by the Gambia? Of course, as Stephen has pointed out, there's probably also a personal element in the sense of you have a justice minister who is well versed with these crimes and realizes the import of this case as well. So that's one aspect. But specifically on standing for the state, the International Court of Justice on the 23rd of January basically said, look at our previous case. Look at the 1951 advisory opinion that was issued by the ICJ related to reservations on the Genocide Convention. And that case actually specifically said that there is a common interest of all state parties to the Genocide Convention to ensure that alleged violations of this convention are dealt with and obligations are adhered to erga omnes partes by all the parties of the convention. So that's one sort of case that the court itself referred to. Of course, you fast forward to 2012 and you've got a case which was Belgium versus Senegal relating to the extradition obligation to prosecute or extradite Hissène Habré. And in this case, of course, keep in mind that it was a different convention or a different treaty. It was the Convention on the Prohibition of Torture. But again, the similar principle that the court elucidated, which was that state parties to this convention have an interest in the obligations being adhered to and ensuring that any violation is dealt with. So those are really the two legs on which this decision, and of course there is a separate opinion in the 23rd January decision, which takes a different view, but that will come up subsequently in the course of the proceedings as well. So those are sort of two important reasons for standing as well. This recognition that you're talking about crimes that go beyond the narrow interest of one state and that they are in the interest of all state parties to ensure that they are adhered to. Having said that, what I will also mention in the provisional measures order is that it was quite a different order that the court issued. And linked to this question of accountability and mass atrocity state responsibility, the ICJ essentially under Article 75 of the statute of the ICJ, where it's allowed to give provisional measures that are not necessarily what have been asked for it. And the court actually took a very unusual decision and issued specifically two measures that I think are worth highlighting. One was in terms of the evidence protection and ensuring that Myanmar did not destroy evidence. So that's part of the legal record and the legal obligation on the Republic of Myanmar. And of course, the second, which was much more intrusive and what the court hasn't done before, was to say that within 4 months of the decision, the Republic of Myanmar was to submit a report on implementation of the decision. So that was the 23rd of May. And every 6 months thereafter, this was again a report that was meant to be given to the court. So, I mean, drawing from this case, I would say there are a few really interesting points I think that we can discuss as well subsequently. One is when we talk about mass atrocity prevention and international justice, invariably the focus is on the international criminal tribunals. And I think in this case, this is the International Court of Justice, which is seen as, it is for state responsibility. It is not for individual criminal responsibility. So it's seen from a slightly different lens, but I think the bigger question is, what is its role in mass atrocity prevention as well? And what is its role in this larger constellation of international justice? I mean, I think that's something we can dwell on. The other is, of course, in terms of the role of the court and, a previous genocide case. So the case of Bosnia versus Serbia. In '93, the application was filed under the convention. There were actually two provisional measures that were issued in April as well as September 1993. And of course, as we all know, the commemoration of Srebrenica, 25 years, was last week, and that happened in 1995. So perhaps one more reason for the court being more proactive in this case, given that that was, something that happened on its watch to an extent. Yeah. I think these are, a few important aspects. The last one that I'll just highlight is the question of fact-finding. And the fact that, the ICJ is traditionally not a finder of fact, and previously has relied, for instance, on the International Criminal Tribunal for Yugoslavia's fact-finding and decisions on genocide. So in this case, it's going to be interesting to see how the case proceeds with, of course, the International Criminal Court case, and of course, with the independent investigative mechanism from Myanmar. So this is really a precedent, and there's a lot that's going to emanate from this case as well.
Thank you so much. That was fantastic. Jorn,
can I just jump in on one thing I wanted to add in terms of how these things are being integrated? Of course, for Myanmar, we have this independent mechanism as well, like the Syria one, established by the Human Rights Council, but then approved and funded by the General Assembly, that's gathering information from civil society organizations. One of the aspects of the way in which these groups work, these mechanisms work with civil society, is when they receive information, they also agree that when they receive it and then send it on to authorities, they give notice to the civil society. They've given that notice, that information that went to the IIMM, it's called, went to the ICC. Recently, some have received notice that that information that they provided has gone to the ICJ case as well. It was questioned whether they would be able to deal with that because that's not a criminal case, but it allows that. So, I mean, we can see the ways in which this system, even though it involves state responsibility as opposed to individual criminal responsibility, is to some extent knitting together to provide the capacity to establish decisions in courts.
Thank you for that. Jorn, the international, and I mean, you know, Ambassador Rath mentioned this, so, you know, this is a very good segue into your question. The international, impartial, and independent mechanism for Syria was established through concerted action at the UN General Assembly under the leadership of Wittgenstein. The IIIM is not itself a tribunal or a court. Instead, it acts as a repository for collection and preservation of evidence to facilitate criminal proceedings. How has the creation of IIIM changed the landscape of international justice?
Thanks, Evita. Thanks for inviting us to be part of this panel today. And as Charles said, it's a great opportunity to celebrate the upcoming International Justice Day, but also to show that R2P and accountability and criminal accountability, I believe, are striving for the same values that are enshrined in the R2P concept, namely more protective societies. To answer your question, and to give a little bit of background for those who might not be familiar with the mechanism at all, the mechanism was created by the General Assembly, as has been mentioned. But of course, it wasn't the first effort to get justice or some form of justice for the people of Syria. There's the famous ICC referral in the Security Council that was vetoed. And there have been other selected justice efforts before, particularly regarding chemical weapons, not individual criminal accountability, but where it was tried to at least find entities responsible for the use of chemical weapons. Now, the purpose, I think, of the creation of the IIIM and the value added is twofold. One, it was the message that we need accountability for sustainable peace, that it's a part and parcel of it as a building block, and that we need impartial justice, not just those focused on a particular set of perpetrators, such as, let's say, ISIS fighters, but that is about the gravity of the crimes, breaches of the Geneva Conventions, gross human rights violations. The second one was the practical aspect, namely that how can our entity, how can the mechanism add value? And that is really this idea of bringing together these diverse sets of data that exist, these diverse set of collection of evidence that has happened, and supporting the justice avenues if and when they present themselves. So I would say the creation of the IIIM led to a diversification of the landscape of international criminal justice actors. But of course, we form part of it. And as Charles had mentioned, it is indeed with the ICC as its centerpiece. Now, to be clear, the ICC does not have jurisdiction over Syria at this moment. But I think for us, what we are trying to do as a body that doesn't have enforcement powers, but that tries to build this evidence collection further, we are trying to learn, nevertheless, from international courts and tribunals when it comes to lessons such as gender and other things in the past, how we can do better. So very briefly, our mandate is then about to collect, to consolidate, to analyze this information and evidence, to apply criminal law standards, which other actors have not done, such as the Commission of Inquiry for Syria by the Human Rights Council, and to produce what we call case files or other analytical products for competent jurisdiction. Competent means that in conformity with human rights standards, fair trial, and that the application of the death penalty doesn't apply for the offenses under consideration. And our mandate clearly says those that are doing it now and those that might do it in the future. So of course, it could be an international court or tribunal if it was seized with the situation, tasked with the situation in the future. And already now we see some encouraging progress, as Stephen mentioned, in European courts, in some other courts, under universal jurisdiction or other forms of extraterritorial jurisdiction. Now it is a new model, I would say, the IIIM, and it has its advantages because we can make use of this flexibility. We can operate with Syrian civil society, with UN actors, with others to bring all this data and evidence together from testimonies of victims, satellite imageries, videos, paper documentation, all of that. But on the other hand, we don't have enforcement power. And I think that's the main point to remember for this model. There's no legal enforcement power, let alone then, if we go further, what you would need for justice, practical enforcement of arrest warrants, all of the things that the ICC is struggling with, right? So it's also a bit of a caveat. It added value to the situation in Syria after other efforts had failed. But of course, it isn't, unfortunately, the new silver bullet. We hope that we can be a building block towards comprehensive justice for the future, and that it will be harder to ignore justice in the future for Syria. Whether and how this model may then succeed essentially depends on political will and what states decide to do and different state bodies decide to do. Very briefly, what we've done so far is we have over 2 million records on file. As I mentioned, very diverse types of evidence. We are cooperating with 11 different jurisdictions that fall within this caveat of human rights standards and other points that they need to fulfill. We have requested over 60 requests for assistance. It can be at an individual. It can be about how you qualify a situation, whether it is an international or non-international armed conflict. And we are directly and indirectly engaging with more than 220 sources, and this is growing. And we particularly see with Syrian civil society the eagerness to be part of this conversation, to feed into these discussions, and that's very, very encouraging. So I would say it is different. It diversifies the landscape of international criminal justice. I don't think we are an end in and of itself. We are hopefully seen as a puzzle piece, as a trajectory, as a building block towards what may come, and nobody knows, in future Syria. And due to the UN applying criminal law standards and giving it this UN, approval is the wrong word, this UN label, I believe that it will be harder to ignore that, because we are not just looking into individuals, we're looking into broader power structures of all these different actors that have allegedly committed crimes, which we often call Rome Statute crimes, in the Syrian context over the last 9 years.
Thank you for that. Does anybody else want to comment on this? Yes, please go ahead, Charles.
Let me just pick up on a thread that seems to me emerging here, okay? And that thread is really about states and political will. And it's interesting that we are having now this mechanism precisely because of the veto in the Security Council. But it is the same Security Council that under the UN Charter has the primary responsibility for the maintenance of international peace and security. It is the same Security Council that determined under Chapter 7, it could use this power creatively for the first time in 1993 to create, by Chapter 7 decision, the Yugoslav Tribunal, followed in 1994 by the Rwanda Tribunal. And of course, now we have the possibility under Article 13B of the Rome Statute of Security Council referrals, essentially an official acknowledgement of a power that already exists in terms of the Security Council. On the flip side of the Security Council, we then get these divisions where, for political reasons, they are not able to make a referral of Syria, despite the states essentially in arms in the General Assembly. You have the same Security Council determining, when it refers Sudan and Libya, that, hey, we're not going to pay for it, so we will not conform to the Rome Statute requirements. Essentially, we're going to pass the work to the ICC and not pay for the work, putting the ICC in a very difficult position where the prosecutor gets this referral and says, okay, I'm going to do my best to look into the situation, but then I'm missing the money. And fundamentally, and this is the point that I want to make, I'm missing the legs to stand on in terms of an obligation on the part of all states to support that process. We know in the Chapter 7 referrals, the only obligation that the Security Council imposed was in respect of Sudan and Libya. That's it. Only those two states. Everybody else, well, we encourage you to help the ICC. We encourage you to help get the justice. So I think there's a fundamental mismatch here between that role where we see the Security Council being very proactive and taking very important decisions and getting justice for Rwandans and getting justice for people in the Balkans. but at the same Security Council that in the current context would get the justice or try to get justice for Sudanese and Libyans and kind of do it a bit half-heartedly. So I think we need to go back then with the efforts of the civil society and those that are mobilizing for the system to move on. And going to Priya's point about the role of the ICJ, I hope the ICJ takes a different approach to the merits case of this particular matter, right? We don't want them to come back and answer in a kind of that wishy-washy way what happened in the Bosnia genocide case. So there are international institutions that, in my view, can work more in a complementary fashion to deal with this element of cooperation, because fundamentally, at the end of the day, if the cooperation and the will is not there, the tribunals, whether they're hybrid, whether they're international, they're not going to succeed, or whether they're mechanisms, they're not going to succeed. Thank you very much.
Anybody else wants to comment on this? Or also on Priya's question, Ambassador Rapp?
I really appreciate Charles' comment. I think all of us who even worked in the UN know that sometimes the resolutions are passed, expectations are raised, and the means aren't provided to actually implement them. And that's one of the dangers and the stresses. Think of people like General Dallaire, for instance, with 270 soldiers trying to protect 1 million people. And perhaps saving 30,000, thankfully, but having to witness all of that, and that is a challenge that we work with. I think the key to all of this is I don't blame the United Nations. I don't blame the people in the ICC. I blame the states for not providing their support, and anyone involved in these things constantly has to work to get the states to go beyond even their treaty obligations. I think of the Yugoslavia Tribunal, which of course had Chapter 7 powers that everybody was supposed to comply with, but Milosevic wouldn't have gone to the court, or many of the later suspects wouldn't have gone if states hadn't conditioned, for instance, aid or EU accession on compliance. And so, and that's what's been lacking often in the ICC context. Admittedly, the resolutions only say encourage, but there's nothing to keep states from saying if you don't comply, particularly state parties. That's going to have consequences, because you're showing a defiance of the rule of law. You're working contrary to these goals that you've agreed to live up to, and use the kind of carrot, sticks, pressures, frankly, that are required in a world of states to succeed. And that's why I think at the end, I mean, we get to this next question. I think we need to think strategically, look at where the forces are, look at where things can be mobilized. It won't be a line like Wellington at Waterloo, et cetera. It's going to be here and there trying to accomplish our goals. But if we do it more strategically, I think we can have a larger effect, even without the support that should be there and that sometimes is required to be there under international agreements.
No, thank you for that. And I mean, it's really the theme that is emerging from, I mean, there's lack of political will, lack of resources, but what came across from all the interventions that you all made was the fact that there's also proliferation of, different kinds of actors which were not seen as people who could actually affect the international justice system, but now because of the retreat, have a new energy to sort of move things in a certain way, and that can be ICJ or the civil society organizations, or this these proliferation of these mechanisms for Myanmar as well as Syria, where with the collection of the right kind of evidence, it will be hard to ignore justice moving forward. And and all of these sort of comments then feed into the question, which is sort of the central question of this event, is this idea that and I would like all of you to sort of think about it and reflect on this, is based on your personal experience, do you think that justice mechanisms can function as a deterrent to perpetrators of mass atrocities? I mean, Ambassador Rapp said that before, that you do the crime, you do the time, and I mean that is becoming more and more the trend. But I mean, but is there empirical evidence to back this, or is this what you feel? And then also, what kind of mechanisms are most effective in your opinion? And I think that many of you have answered this question in different ways, but I mean, if you can just reflect on this conundrum. Yes, Leone, please go ahead.
Then let me kick off. There's this saying, for the law to be effective, it must change minds. And I think what we all need to remember is that these mass atrocities do not happen overnight. They do not happen by accident. They require detailed planning. They require execution. They require power structures, right? And in warfare, what I do is I calculate what can I get away with, what puts my entity at an advantage, and what is the cost. The cost can be me individually facing trial. The cost can also be the reputational cost of my government, of my non-state up group, of whatever entity I represent. And I think that's the two elements, I think, where we look at deterrence. The deterrence is, one is the individual deterrence, and that's important. But I think criminal accountability has this potential to look at broader power structures, to look at the architecture that's behind committing all of these atrocities. And that's where we need justice to have teeth. And teeth is what all other panelists have said. It's about having legal enforcement power, but it's also about having practical enforcement, execution of arrest warrants. It's about the political backing and support. Whether or how it's phrased in a Security Council resolution is one element where it can be, but it must be broader. I think for Syria, for instance, we see the cases in Europe are fantastic, and they are good developments, and war crimes units are beefing up their capacities to do this type of investigations, at least in the Syria context. And it sends an important message to victims and survivors. But I think the message we need to solidify is that accountability is not a question of when, but only a question of if. That when time comes, we are catching up with it. And for the Syria context, I think the important thing is this cannot be the new standard of what is acceptable in conflict. I mean, if this is the new standard, what is acceptable in conflict globally, it's a catastrophe, because all the laws, Geneva Conventions, others that we have come up with, nobody respects them. So we need to allow the judicial process to catch up with this and build the political will to do that in order to have legal findings from courts. Not that doesn't devalue the product of an NGO, but if I have a range of legal findings that prove that war crimes have been committed, this has a different weight, right? And if I then have the political backing that those who did it can't get away with it, again, not just the individual, but the entire structure. Because if this is absent, any actor will use more likely to use atrocities to stay in power or to get into power. And I don't think this is the world in which we want to live. I don't think this is the world what the Utopia concept stands for. If I do not only fail to protect my people, but if I deliberately violate this obligation in this entire process. So I think for a real conversation about deterrence, we need to be able to align these different points. It's very difficult to quantifiably and qualifiably say whether there is or isn't deterrence. It's very hard. But I think we nevertheless, we know what we would need to do to actually get to the point of making sure that atrocities stop and are no longer committed in a particular conflict, as well as more broadly in future conflicts, which I assume we will still see arising at some stage.
Yes, Ambassador Rapp.
You're mute.
We can't hear you.
I didn't click it hard enough. Anyway, I agree entirely with what Jorn has said. And before I was an international prosecutor, I was a federal one in the US, and federal ones, the states do the heavy lifting, the feds come in and do certain cases with broad impact, and always looking at that kind of strategic approach. And when you look at cases like environmental crime or financial crimes of certain sorts, you can actually see that by targeting effectively, you can change conduct and have that kind of impact, because you've got rational actors who say, this is a risk. I could go to jail. Our company could be prosecuted and out of business. And so you can have that kind of effect. And those of us that have looked at these various atrocity situations see very capable leaders who calculated political risk as they've risen in dangerous places. And they look at this, et cetera. And maybe when they go all in like Assad, it becomes hopeless. But before they get there, I think you can have an impact. Charles has talked about our experience in Sierra Leone, and it was imperfect because there weren't really national prosecutions because of the Leone amnesty and other reasons. And we only charged 13 people, but there was an approach to the high-level actors and to each of the armed groups, indeed even the government that had fought on the side of the democratically, or the movement that had fought on the side of the democratically elected government, the so-called Civil Defense Force, and indicting its leadership was quite controversial. but actually succeeding in those in the case where the surviving leadership was convicted, I think had an important message. And I remember later on when there were elections in Sierra Leone and power, which has now changed between political parties twice by relatively narrow elections, and been accepted. You know, I've heard people say, well, we learned at the special court that you couldn't gain or hold power through this kind of violence. Of course, the court's not there anymore. But I think that even though there should have been more done, I think in terms of domestic capacity, it's had that impact. I think the lesson for the ICC is a little more challenging, just stepping in and out of situations and having one or two cases. And I think wherever they go, they need to be thinking and working with states more on not just the complementarity in the sense of staying out because the country's doing it, and that requires the ICC be viewed as a robust challenge. People say, hey, I don't want to be taken to The Hague, let's do it at home, and that's been one of the problems. That's the thing that I call sort of like coercive complementarity as opposed to say positive complementarity, providing the assistance. But there needs to be an approach also to situations where there's one or two cases done at the ICC, and then work needs to be done, like the former Yugoslavia Tribunal did, working with the domestic systems to make it possible to handle the mid-level and low-level people and really have that kind of impact. And frankly, with the exception of a few states that have helped, all our talk about complementarity, when we go to the development agencies, they want to spend money on corruption or independent judiciary or one issue or another. And there really isn't a consolidated global effort to strengthen capacity for these Rome Statute crimes. And those of us that get involved in these situations, they're trying to get help for these states, find out that the monies that are available are extremely limited. We see that now, for instance, with the special court in Central African Republic that's trying to make do on a 10 million or so budget a year and deal with all of the situations that the ICC can't that involve at least armed actors. And so there needs to be a commitment in that area if we're going to be effective.
Priya and then Charles.
Thank you. I mean, I think I'll just sort of draw a bit upon what, Jorn and Steve have said, but I think the first thing I would do is also sort of step back and say, what are we talking about when we say deterrence? Are we talking about a general broad sweeping notion of deterrence that is akin to a domestic criminal system? I don't think so. I mean, I think that's sort of very sweeping and it's very hard to prove a counterfactual, So are you saying that a war crime prosecution in X country is going to have the same deterrent effect in another country, in another conflict and a different situation? So I think we need to calibrate that into saying, are we talking about specific deterrence in a specific context and conflict as well? I mean, that's one which of course is hard also empirically to determine. But I would borrow a phrase actually by Catherine Sitting, who's written a lot about, deterrence and international justice especially, and the phrase is interactive global systems of accountability. And I think that really draws on what Stephen says and what Jorn is talking about in terms of complementarity, looking at national domestic legal systems as well. And to be honest, I mean, for us, a determinant of ICC success really should be not just prosecutions that are successfully completed at the ICC, but at domestic national level prosecutions that ensure accountability and rule of law. I mean, maybe it's being a bit naive or maybe it's, being very idealistic, but I think that's sort of the structure that we really should envision as well. With that, I mean, the other thing that I would also say is, we're talking about, I think, prevention in the larger context. We're also talking about accountability. And as Jorn said, these things don't happen in a vacuum. And I think we also need to start being quite cognizant of the fact that there are serious problems in terms of rule of law, not just in terms of prosecution of these crimes, but also in terms of the enabling environment that creates the ability to, to go forward and commit these crimes. So, I would say we also need to start looking at the red flags in terms of preventative mechanisms and looking at, for instance, citizenship and statelessness laws. If you look at the Myanmar context, 1982, the citizenship law was one that enabled the marginalization, discrimination, and eventual, persecution as a crime against humanity and genocide. So I think we need to also look at that in the broader, more holistic sense of how we approach deterrence and international justice as well.
Thank you. Charles, please go ahead.
Thank you. I'm just going to build on and basically agree with everything that has been said by Leone and Stephen and just now Priya. I think the challenge to think of deterrence in the kind of domestic lens is that we are essentially attempting to transpose something that's more familiar, that we've dealt with for a long period of time, to the international level, effectively expecting this two-part categorization of general deterrence on the one hand, and on the other hand, specific deterrence, something that Leone had alluded to, would map on very nicely onto the role of the tribunals. And I've always wondered how much of this transposition that we attempt to make can be justified, given that when you think of what's happening at the international level, you have a system essentially where we are trying to say there are some things that are so beyond the pale, they are so bad, so awful, that as an international community, we've condemned them. So essentially, we're going to keep this obligation, let's say, for example, genocide, which nobody would contest, right? Nobody contests genocide, right? Everybody accepts that. And the ICJ has said it's customary international law anyway, so you don't even need to be a party to a treaty anymore. Okay, that's great, right? Now, when the states that are supposed to be bearing that obligation fail to do something about it, the system that we've envisaged is that there will be a backup, right? This is sort of where Priya is driving us to think about the wider context of, okay, what are the duties of others? And in the context of the conversation we're having, we're talking already, of course, of R2P and other things, right? The element of prevention. And when you think about prevention, in a sense, I've always had the sense that the English have it right when they say an ounce of prevention is worth more than a pound of cure, right? Because it will actually prevent the atrocities in the first place. When you think about the cost and the headache and so on, we actually save ourselves so much. Of course, we don't live in a perfect world. So what we have out there right now are early studies, including somebody that Priya mentioned, Catherine Sickink and others. I think Nuremberg Academy did a study not too long ago, essentially trying to track the deterrent effect of these tribunals. Yes. And I believe that the early evidence suggests that there is. But I can tell you anecdotes, personal anecdotes. I mean, this is the difficulty of anecdotes, of course. It's like you don't have a way to verify what I said. But I've sat across individuals who Stephen indicted, okay, who told me if they knew now what would happen, if they knew then what would happen to them now, where they were sitting, they were not going to do it, right? So if there's an example of a specific deterrence of a defendant sitting in jail with 17 counts of war crimes, crimes against humanity against them, and they say, you know, if I could do it differently, I probably would. It suggests that there's something there. In any event, for me, that's beside the point. We got to focus on the responsibility of the state, because sovereignty does have responsibility entailed within it. But then there's also the responsibility of others to step in. And at the ILC, interestingly, where we were debating this idea of a global multilateral convention on the prevention and punishment of crimes against humanity, I was the only member that kept raising R2P. And I was thinking about R2P as a potentially useful device that the commission could think of, obviously not at the level of codification, because the ILC has that mandate, which is the famous mandate about codification. This is more in the arena of progressive development, right? And ultimately, of course, the device and check for sovereigns is that all of this will be proposals to the states in the General Assembly, and if they like it, they can take it. If they don't, they can even modify it. But essentially to say there ought to be a duty on all states so that if crimes against humanity are occurring and the territorial state that has first responsibility fails to do so, then others might step in. And that idea there could well be like a deterrent for somebody to just kick back. So we end up with, hopefully, in a world where more states than the Gambia will be willing to step up and say, you know what, I'll see you at the ICJ, because yes, there's an inter partes element here, but there's an erga omnes element as well. So I think it's a fascinating conversation, but in a way, we have to broaden it out and look at the promise of the international system and what it can do to deal with atrocity crimes. And if I have a preference, I have to say, I mean, the national, international, we've done very well with that, I guess. But I think hybrid courts could also play a very useful role. I'll leave it at that. I know others haven't had a chance to intervene on some of the elements. Even if you want to come back to that or to questions later on, I could say a few things about hybrids.
Does anybody want to comment on each other's statements? I mean, no, this was really, really fascinating. I mean, complementarity. I mean, taking complementarity seriously, taking sovereignty seriously, and taking the fact that, I mean, in the end, you're not just, it's not about individual prosecutions, as, I mean, Stephen said this, and Leone, I mean, it's about sort of thinking in terms of power structures. And I mean, and in the context of atrocity prevention, very much, I mean, guarantees of non-recurrence come only when you attack the root causes. You think about, the structures that have that have led to the perpetration, unless and until you address those, you're not going to you're not going to be able to prevent future crimes, and you cannot get guarantees of non-recurrence. I mean, this is a really fascinating conversation, and we can, spend an entire day just talking about this. But we have a couple of questions from our audiences, and I know Charles and a couple of other people had very much wanted to speak about universal jurisdiction. So this question comes from our audiences, and universal jurisdiction relies on the capacity and willingness of individual states to prosecute, as well as their respective domestic legislation. Given that all these factors are disparate across states, how does this impact justice for victims of atrocities? Does it produce an uneven ad hoc system, or is there a way to standardize application of universal jurisdiction across diverse national justice systems? Who wants to jump in? Ambassador Rapp?
Happy to jump in, but obviously it is hit and miss, and to a large extent it depends upon the presence of an offender, because I think universal jurisdiction, where the country doesn't really have a dog in the fight, so to speak, it deals with a situation where it doesn't have the perpetrator, it didn't have the crime on its territory, it doesn't have its own citizen, at least at the time the crime was committed, in its territory. You really need a connection, a nexus, we recognize. And sometimes the people that turn up are not the high-level offenders. They may have, in fact, even defected from the regime at one time or another. So you've got those kind of challenges. Obviously, these cases also generally take effect long after the crimes. I mean, there have been convictions of, I think, Rwandans in 12 different countries. Those are generally low-level persons. I remember testifying against a person who was a school janitor who'd played a key role in the massacre of one community, but had come to the United States and lied on his form and ended up with a 15-year sentence, et cetera. So these cases are symbolic in a way. On the other hand, there is this interest, particularly, and it's not so much in universal jurisdiction, but in the passive personality area. Like France doesn't have universal jurisdiction to actually charge people, but where they have victims like the Dabas, father and son, who worked in this French lycée in Damascus, very beloved family, ended up both father and son tortured to death by the regime. They were French citizens, Syrians also, dual nationals. That enabled the French to look at who was responsible for it. And they put out international arrest warrants against Ali Mamlouk, the head of the National Security Bureau, one of the most powerful people in the country, against Jamil Hassan, the head of Air Force Intelligence, because they'd been tortured to death in the Air Force Intelligence facility, the so-called Jawiya at El Meza Air Force Base. And so, they reached out. Will they get those people? The Germans also have an indictment against Jamil. But of course, it took 16 years for the ICTY to get Mladic, et cetera. And we know what happened in the great emblematic case of universal jurisdiction, Pinochet. The Chileans didn't think there'd be any chance he'd face justice. Senator for life, they weren't even particularly enthusiastic about Garzon's efforts, and then lo and behold, he gets arrested in the United Kingdom. The United Kingdom finds there is jurisdiction under the Torture Convention, at least in their House of Lords and their final decision. He's sent back for reasons of health, and then Chile begins a more comprehensive approach to justice. Of course, he dies before his case is concluded. But I think you see universal justice then playing to some extent kind of the role of an ICC on complementarity in a way. I mean, justice is there, then, what are you going to do at home? Liberia is a fascinating example right now. Hassan Bilady, who heads the Global Justice Research Center in Monrovia, working to develop witnesses, working with Civitas Maxima out of Geneva, my friend Alan Werner. They've now got 6 or 7 cases going, United States, UK, Belgium, Switzerland, France, where there's prosecutions of sometimes some pretty high-level Liberians that have gone abroad. And that's actually awakened the demand in Liberia perhaps have finally a special court for Liberia. So I think that, and it's also a signal that whatever way people try to deal away and forget justice, these echoes from abroad actually begin to have impact back home, because in the end of the day, much better to do it there. And so I do see it having that impact eventually. What I would like it to do more in the short run is to be more strategic in other countries and not always deal with the school janitor. Try to find the highest level guidance there, work with the IIM. Some countries can do a case on this basis, some on this basis. If we had a more strategic approach, we could get something more similar to a hybrid courts approach. And that's difficult because every state has its own priorities, its own units. And frankly, many of these are profoundly under resources. Maybe a lot of people working on terrorism cases, but very few working on the cases involving international crimes specifically.
Thank you. Charles?
So if I could jump in, and I think I follow nicely on Stephen, because he's talked about universal jurisdiction and some of the encouraging signs that we see, especially when it comes to the use of passive personality type jurisdiction, instances where the states show an interest because a national has been affected, and we see this in the Rwandese cases in France. We saw this in the Rwandese cases in Belgium and even Spain. There was sort of like that first early wave, and now we kind of see universal jurisdiction coming back, so to speak, because of course, as we all know, it kind of went a little bit into the ice box when we had the famous arrest warrant case, where the International Court of Justice basically refused to deal with the question and dealt with the element of immunity, and sort of essentially said to Belgium, look, maybe you're too enthusiastic, so why don't you kind of calm down a little bit, which is unfortunate because it kind of dampened what was then seen as the rise of universal jurisdiction. Now remember, universal jurisdiction had been invoked in the famous Eichmann case in Jerusalem, right? Like, remember Eichmann, who was basically brought back way back in the 60s to Israel to basically stand to trial that would not have been possible in the country that was hosting him. And yet, because of that first phase, a set of questions about universal jurisdiction have come up. And they've come up at the bilateral level in terms of disputes between states. So obviously the arrest warrant is a good example. The DRC takes Belgium. Obviously they are tied to the question of immunity of officials and so on. We saw at the regional level and a big spat between the African Union and the European Union. So the AU-EU kind of dispute over universal jurisdiction. And then at the international level, we saw an escalation of this question where the African states brought the matter to the General Assembly and essentially put this item, initially named the abuse of the principle of universal jurisdiction, and the item was renamed the scope and application of universal jurisdiction, and it's been on the agenda of the 6 committees since 2009, okay? Now, let's look at what has happened. Since 2009, states have had an opportunity to clarify the scope of universal jurisdiction. For example, what kinds of crimes can be subject to universal jurisdiction? Is there agreement? Is there some practice that can support that? No progress has been made on that. How do you apply universal jurisdiction? How do you coordinate universal jurisdiction with the territorial jurisdiction of the states of, let's say, origin of the person, who may now, if you think of it from the point of view of the countries that require presence, may now have the custody of the person? Again, no agreement, down to the bad news that they cannot even agree on a definition of universal jurisdiction. So what does that mean? From the point of view of the international system as a whole, I had the privilege of becoming an ILC member who's worked a lot in this area. So I actually proposed in the context of the International Law Commission that the commission, which is a general commission that is well healed to deal with questions of jurisdiction in a global way, giving its global representativeness, to take up the issue of universality. And to my colleagues' credit, the commission put this on the long-term program of work. It's gone to the 6th committee for 2 years now, and look at what has happened. You have a whole bunch of states that have lined up in support of an ILC study, but you have a perhaps slightly smaller but very loud bunch that do not want the ILC to study this. Interestingly, in some cases, countries that were the, if you will, founders of universality, right? And I'm not gonna name names. I gave an example earlier, it tells you. So all to say that as a way forward, the law could be well clarified. The law could be at least put on a certain level now where, based on practice, we could kind of find what can be codified. We can find areas of progressive development that we give to states. But at the moment, it seems politically the mood is not right. And I'm doubtful that the ILC would go forward with it. But it's unfortunate because it's a lost opportunity if you situate it in this bigger discussion about the place of universality in the effort for accountability, because there are well instances where European courts, North American courts, courts elsewhere, even African courts, if you think about what happened to hybrid, can take the lead and use a universal jurisdiction type idea, even if it's based on a treaty as the Deterrent Convention, to give us more justice than in the case of hybrid that he would not have had in his home country, because Senegal stepped up, perhaps because of complex reasons, but in the end, with the support of the AU and international partners, they got some justice. I mean, as limited though it may be, some justice for the victims of hybrid crimes. So I think there's an interesting dynamic here, and maybe for those who are out there who may be states, to maybe see whether they can support the ILC proposal, because that could well be a small concrete thing that can help give us more clarity in the push for accountability. I'm not going to be my own advocate, so I'm going to stop there. It will already be distasteful enough. So thank you very much.
Joran, please go ahead.
Thank you so much. And I agree with everything that has been said about universal jurisdiction. And I said in the sixth committee where there was in universal jurisdiction discussion, so what Charles said is absolutely right. And I think all credit to the International Law Commission. But if you want to start something with consensus on something that is as contested as universal jurisdictions about their reasons why perpetrators of these crimes are not being held accountable in their own country, right? It's obviously very difficult if you set 193 states as the bar to the starting point to agree on something. And that makes it very difficult, internationally speaking, to find consensus on universal jurisdiction. At the same time, I think it is important to note how important universal jurisdiction is, and that's precisely what Stephen had said. Because often it is the only justice avenue available. It can send this clear message that there is not this absolute impunity. Human Rights Watch did a study about Sweden and Germany, which they called Cracks in the Impunity Walls, or something like this in the title, I think, which illustrates this very well. And it can help a momentum, because it can inspire more states to start these investigations and to increase the capacity of chronically underfunded international investigation units. It can also help to develop jurisprudence and customary law, right? If we have a number of legal decisions of how certain IHL rules apply, don't apply, how a certain conflict is classified, can be super helpful for the contextual elements of the crimes. And ideally, if states are able and willing to prosecute broadly, meaning from different sides of the conflict, and not only, for instance, let's say ISIS fighters, which receive more attention, it can be meaningful. It can be a step towards impartial justice. It can be a step towards victims who can see these things. It is still not the solution, but it is hopefully an interim step. Again, if we look at this entire process in the trajectory, as others have said, justice takes so long in these conflicts to catch up, right? So the more we can do while a conflict is going on, or the more we can do at the moment when a conflict is ending, for instance, or even starting, I think the better we are then set up, combining all these little puzzle pieces towards this larger landscape of international criminal justice that we've been talking about today.
Thank you for that. Priya, do you want to comment on this?
Maybe just to add one very small point, which is, Trial is one of the organizations, CSOs, that works a lot on universal jurisdiction, and has come out with a recent 2020 report, I think just a few weeks ago, and I was going through that. And just one thing that struck me from, Joran's point on ISIS and specific actors, there seems to be a bit of a turn to looking and charging more terrorism crimes than other international crimes as well. So I think that's something that we need to be aware of. And, to Charles' point of maybe greater sort of cohesion in terms of how universal jurisdiction is used, that's something that definitely, we should look at more seriously, and more part of the ILC to push that through a bit.
If I may, for 10 seconds, I agree entirely with you. And I think for victims and survivors, it's important that perpetrators are charged for the harms that they've done to their communities. For the crimes that they've done, whether it is sexual and gender-based violence, whether it is unlawful attacks, it doesn't matter. It is they can of course also be charged for terrorism affiliated charges. But if states have the opportunity and the capacity to charge crimes against humanity and war crimes in addition to terrorism affiliated charges, we can break this gridlock where it suddenly becomes, well, we only talk about terrorism because that's our national security interest, and what is happening on the other hand is not so relevant anymore. These two agendas can be reconciled and should be reconciled for the interest of the society with which the relevant state or jurisdiction is dealing with, hopefully.
And if I could jump in for also 20 seconds, I mean, the Dutch recently had a case where they charged both terrorism and the war crime, and that's something that the European Network on Genocide Prevention and enforcement is really trying to push to work both of these. And of course, in the whole foreign terrorist fighter area, we also have situations in Europe where sometimes the terrorist crime that can be prosecuted may have a very low penalty unless you can prove actual conduct. Sweden, for instance, has no terrorism statute. So they need to make these cases as war crimes cases. And there's been recently the proposal of a Malta state court, for instance, to deal with the foreign terrorist fighters. This opens up a new avenue potentially. Obviously, if such a court were created, it shouldn't deal exclusively with with foreign terrorist fighters. It should deal with other actors in this space, and states could pool their jurisdiction. That's one of the more exciting ideas that are out there. Whether there's the will, the resources to do that, it's one idea that's on the table.
Sorry, Savita, 20 seconds.
Yes, absolutely.
Okay, sorry. So I'm going to follow Stevie and you on this. Just to say, I want to be very clear because I don't want to caricature the Commission. The Commission hasn't taken a decision yet on whether it would now, because we have a two-step process. So a step where we propose an item and put it in the report and notify states essentially to get their feedback. And so that step has been completed. So the Commission now has to take the second decision as to whether it would take that item from the long-term program of work. And there are a number of considerations, the potential for the topic, how much support obviously got in the 6th committee among states, the likelihood that the Commission can add value in the views of states, and obviously the availability of a special rapporteur and space on the program of work. Now, on some of those elements, we're in a good place because the Commission has been wrapping up quite a bit of its projects. So, for example, last year it concluded its work on crimes against humanity, which is the draft treaty that was presented to the General Assembly. And on universal jurisdiction, there is a lot of support in the 6th committee that is actually distributed widely, but also some opposition. So, and I think this is something that the Commission will be looking at because ultimately, obviously, the idea is to help states to clarify what they can work with, so that we do not have some of these disputes that we see. I mean, that's the page. But on the other side, we don't want to also obviously be walking into essentially a project that, and the Commission has done this in the past, a project that has no promise because it's going to be attacked by the states that are unhappy with it. So it's a very delicate balancing act. But personally, I'm very hopeful that the Commission, even if it leaves some deference now to the 6th committee that has been addressing the question since 2009, to give it a bit more time, perhaps, to think of it, maybe it could come back to it later on. So that if the mood is a little bit more right, then the Commission could add value for them. I leave it at that. It's more than 20 seconds, but thank you for your indulgence.
No worries. I mean, we are now coming towards the end of our event, but I just have one more question from the audience. I mean, we have many questions and we can just only take one more. And this is very much sort of victim-centric. So how can victims be meaningfully involved in the design and implementation of justice processes in order to ensure that such processes address root causes of atrocities and promote the non-recurrence of violence? So just very quickly, if you guys can just give us a snapshot, that would be fantastic.
Priya should start.
Please go ahead, Charles.
And I was throwing my friend Priya under the bus to say she should start because she works with the NGOs. But let me just say very quickly, I think that, I mean, obviously, depending on the mechanism, there's a strong place for victims. If you think about the ICC, for example, I mean, we haven't had the kinds of developments in relation to victim participation and the idea of reparations and so on. Obviously, there are some challenges there because we have a trust fund that has no money, and as cases have been completed, the question of what reparations you can give would remain. That was a significant advance compared to the ad hoc tribunals that we've been talking about all morning. And in other contexts, we talked about the ILC earlier, there's a strong provision on victims in relation to the ILC draft articles on crimes against humanity. Really fascinating, that really draws on developments in the area of human rights to include some element of obligations on the part of states that were generally very well received in the General Assembly. So I'll leave it at that. Just 2 points about depending on the system, there's a strong victim role. And we hope that that would continue because the commitment is necessary for why we're doing all of this. Thank you.
Stephen.
Yeah, and I do think, I talked earlier about the bottom-up justice, and the victims played such an important role in this third wave. And we only have to look at the case in Germany came from ECCHR representing the victims, the case in France from FEDH, we talked about trial and other groups. But let's go back to Habre. If you watch that whole case, Suleiman Gang, you know, and Jennifer Medina, Jacqueline Medina, they were the people that made that case happen. And then when it went to court, they were very active in their counsel, at least as active as the public prosecutor in calling witnesses and presenting evidence. So those of us that come from common law where the victims don't have a role, except maybe at allocution, at sentencing or something, have really seen the benefit of that. And I think it calls for us as we develop institutions in the future to make sure that we have this kind of active role for victims to bring their case forward in ways perhaps, I mean, it may be more limited in an international court, but at least that ability to bring your complaint forward and pursue it judicially and then have the prosecutor take it over and you continue to assist, I think is a model that we've learned works and can really make the justice, I think, more meaningful. It has to be contained to keep the cases from going on forever, but without it, we wouldn't have the engine that we have right now.
Priya?
Very briefly, I mean, I think there's been an evolution as well in terms of victims' representation and how involved they are in the processes of international justice. But I do feel that, you know, the International Criminal Court, for instance, you look at Article 15, there is a scope for victims' representation, which, you know, in the recent case with Bangladesh and Myanmar, there were representations that were put forward by the victims. And, you know, this was really relied upon by the pretrial chamber to authorize an investigation as well. So I think there's a much more sort of central role. And I think that's being recognized also within the Rome Statute, within law as it's developed now over the last 20 years. So yeah, more central, and that's crucial.
Leone, would you like to add something?
Sure, I think we are seeing a transition towards more holistic justice. That is looking at, you're not just looking at mass graves for the sake of criminal investigations, you're looking at mass graves also for the sake of the missing. And ideally you have these two actors talking to each other, that you don't open the mass grave twice, but that you open the mass grave once. And it's these things of, and I think when we talk about victim and survivors, it's looking at the person in their entirety. Someone can be a victim and at the same time can be a survivor, or someone can just be one of these two things. And there's a whole referral pathway to other actors and entities that look at this process together when we talk about transitional justice and so on. I think the beauty of modern technology, the beauty of all that what we are seeing, and in a way proliferation, is that we have opportunities to learn from the past and to bring this more together, to deal with these sensitivities and to find more ways and means that are in the interest of victims and survivors, and not just what we perceive as their interest, but actually facilitating dialogue to for us from practitioner side correct maybe misperceptions that we might have, but also to then better be able to implement this into a meaningful process, and ideally that gives a level of ownership. But I think the biggest point is what we need to continue is we need civil society actors to make as much noise as possible, because in particular in a world where multilateralism is arguably under threat, and international law is one of them, because it's at the tip of the iceberg, which courts and tribunals making decisions. We need a commitment to these values, and we need to have civil society and those affected to call out actors, because that's one of the best ways to create momentum. And even when an issue or a situation or context may fall off the international news because of other developments, that we keep on having this persistent and consistent reminder. And even though it's frustrating, we can see that it leads to results longer term, and how important these voices are.
Thank you very much. We are completely out of time, but I just want to sort of, are there any last words you want to say, or should we just close the event? Thank you very much for taking the time and very patiently answering all our questions. And we really, really appreciate it. Thank you to the attendees. I hope you benefited from this discussion as much as I did. And I would also like to thank my Global Center team for all their effort, particularly Juliet Power, Jahan Pitalwala, and Jacqueline Stretful Hall. Thank you very much, and we hope to see you soon. Stay safe, stay healthy. Bye-bye.
Thank you and goodbye.
Thank you, Sarita.
Bye. Bye.
Bye-bye.